All right, so the religious freedom update this week, I'm going to leap off of Fulton again. We talked about that last month, but some of you, may know after the Fulton opinion came out, I wrote an op-ed in the Deseret News talking about how the Supreme Court was still, at the end of the day, not resolving. It wasn't giving us some rule or guidance on how to resolve the various disputes that come up when you've got LGBT rights conflicting with religious freedom. And the argument I made in the op-ed was that as a society, we cannot just sit back and expect the Supreme Court to resolve these problems or expect the judiciary to. We're going to have to do the hard work of living as a free people and come up with some type of legislation that's going to allow us to survive and live alongside one another. And until we do, it's just going to be decades and decades of continued battles. I think you're seeing that now just playing out already. It's only been a month and a half or something since Fulton came out, but almost immediately afterwards, the court denied cert in Arlene's Flowers, which was a case substantially similar to Masterpiece Cake Shop out of Washington. A lot of people expected the court to take that and it didn't. And then there's all these other cases popping up all over the country. Masterpiece Cake Shop has been in court fighting literally since the day the court granted cert in its case, and just lost at the district court level in a civil suit brought by a transgender attorney suing Jack Phillips for discrimination. You've got the exclusion of a Christian ministry from Amazon's charitable giving program, because the Southern Poverty Law Center has designated it as a hate group simply because it teaches that same-sex sexual intimacy is a sin. You've got a website designer in Colorado that is subject to Colorado's Anti-Discrimination Act and is also facing serious fines and being shut out of business because they can't design websites for same-sex weddings. So there's others happening around the country. There's never as many of these cases as the media likes people to think, but they're happening. And the point is, both sides are going to continue to get wins and losses, and they're going to go back and forth fighting forever. Far better to find some solution. I think the solution is out there in many respects in the Fairness for All Act. You can quibble with the details, but the spirit of the Fairness for All Act is the idea that we can find a way to find legal compromises that allow both of these groups to live alongside one another in society without having to compromise their core identities. And until we get something like that passed, I think we're just going to continue to look at a long string of litigation with each side, winning and losing as they go. In other news, though, because LGBT rights cases make up just the tiniest sliver of religious freedom cases out there, there are other things worth watching. There's lots of talk among those in academia that the Establishment Clause is essentially dead and the Supreme Court will never enforce it again. I'm not that pessimistic, but I understand where they're coming from. And I do think that it is the case that the Establishment Clause is not talked about nearly as much as the Free Exercise Clause. But just to give you a sense of some of the types of things that are happening around the country, a federal court in Massachusetts allowed a claim to go forward by the Satanic Temple because it was denied an opportunity to open a city meeting with prayer. And so you've got the Satanic Temple versus the city of Boston, and that's going to progress. It's an Establishment Clause challenge, essentially saying, look, if you're going to have invocations for these city meetings, then you need to allow all comers to say these prayers, and arguing that they weren't doing that. I don't know the exact details of all the facts on the ground. It's just barely at the beginning stages of the case, but now we're getting discovery and we'll see what's actually happening. In another case, the 10th Circuit ruled and held that qualified immunity does not protect prison officials who banned Native American religious services for at least 9 straight days. And so that case is going back down, and if qualified immunity is not in play, that poses some serious risks, of course, to prison officials. So it'll be interesting to see what ends up happening with that as it goes forward. These prisoner right cases are constantly percolating in the lower courts, and the question of qualified immunity for prison officials is kind of a big deal in those cases. So that's just a smattering of some of the stuff that's happening around the country. And we'll look forward to an update next time. Anybody have any questions or anything before we stop recording for the update?
I'm curious about your thoughts if you followed the recent case from the 10th Circuit in one of these LGBT related marriage services cases. It's more of a free speech case, I suppose, but it basically said that the state can compel a Christian designer to design websites and announcements for LGBT weddings. And I'm curious about your thoughts on that case, if you've seen that opinion and had thoughts on it.
Yeah, so that's 303 Creative LLC versus Alennis. I don't have any strong opinions about it, except that I think that we haven't heard the end of it. I mean, more and more of these cases are going to start getting into territory where it's obviously speech. ADF and other groups are really pushing these cases on the speech front. And as you'll recall in Masterpiece, the Supreme Court was hesitant to jump into where does speech begin and end, because that's a line that's very hard to deal with. And so they've been successfully handling these cases either by denying cert or resolving them on free exercise principles. But as you get into developing websites and things like that, you're going to get more and more into what is clearly speech. And at some point, I think the Supreme Court's not going to be able to ignore that anymore. I don't know how that's going to play out, though, or how it's going to be handled. We'll just see as we go. I think that's my only thought on that. Dan, do you have any other thoughts for the good of the order on it?
Oh, my thought is that I thought Judge Timkovich had a very powerful dissent in that case. I would recommend that to anyone who's interested. I thought he did a very good job pointing out that what the state, the reasoning of the state was basically you are offering a unique service and therefore there's no alternative to your service. Therefore, we have a reason to compel you, and there's no alternative, no least restrictive alternatives we can offer. And he points out that that's exactly backwards, because the speech is expressive and individualized. That's all the more reason that the state should not be able to compel expressive activity that violates one's conscience. So I thought Judge Timkovich did a very good job, and I just commend that dissent to anyone.
Yeah, I mean, the case does a good job of especially fleshing out the arguments on both sides, and I'll be curious to see what the Supreme Court does. My guess is there's at least 3 justices who would love to take it. Who knows if they'll get the 4th or not? We'll see. So, okay, there's your religious freedom update for the month.